Hi and welcome to SQE Success, your pathway to becoming an English solicitor. In this question bank series, we'll look at 3 questions on the remedy from breach of contract, which falls under contract law in FLK 1. Let's dive in. Here's the first question we tackle today. A man entered into a contract with a building contractor to construct an extension at his home, which included a garage. The design and construction plans clearly specified that the garage should measure 28 feet in width and 14 feet in depth. However, upon completion, it was discovered that the garage was only 27 feet wide and 13 feet deep. The man has now brought legal proceedings against the contractor, seeking £50,000 in damages, which includes the cost of demolishing and rebuilding the garage to the correct dimensions, and costs associated with off-site storage of his car, as he considers the garage to be unusable. It is found that the man's car can actually be stored in the garage, despite the room on each side being a bit tight. The contractor has instructed a solicitor to advise on how to defend the claim, particularly in relation to the amount claimed, quantum. Which of the following best describes how the contractor may defend the claim? A. The contractor can defend the claim on the basis that the man is entitled to recover only for difference in value or loss of amenity. B. The contractor cannot defend the claim because the man is entitled to the full cost of reinstatement. C. The contractor can partially defend the claim by arguing that the man is entitled to difference in value or loss of amenity, rather than full reinstatement costs. D. The contractor cannot defend the claim because the man is entitled to damages for loss of amenity. E. The contractor can defend the claim in part on the basis that the man is only entitled to restitution. You can pause the video and think about it. The best answer is C. The contractor can partially defend the claim by arguing that the man is entitled to difference in value or loss of amenity, rather than full reinstatement costs. In building contract cases, the court considers whether the cost of reinstatement is reasonable and proportionate, or whether the appropriate measure of damages should be difference in value or loss of amenity. This principle was highlighted in cases such as Ruxley against Forsyth, where the court held that reinstatement costs will not be awarded if they are disproportionate to the actual impact of the breach. In this scenario, the difference in the garage dimensions is relatively minor, and if the garage is still functionally usable, the court may consider cost of rebuilding excessive, and instead award a lesser amount based on diminished value or loss of amenity. Let's look at another question very similar to the first question. A man entered into a contract with a building contractor to construct an extension at his home, including a garage designed specifically to house a large commercial vehicle. The building plans clearly stated that the garage should measure 28 feet wide and 14 feet deep, as these dimensions were essential to accommodate his vehicle. However, when construction was completed, it was discovered that the garage was only 27 feet wide and 13 feet deep, making it entirely unusable for its intended purpose. As a result, the man has issued a claim against the contractor, seeking £50,000 in damages, which covers the cost of demolishing and rebuilding the garage to the correct specifications, and temporary off-site storage costs for the vehicle. The contractor has asked a solicitor whether the man is entitled to recover the full cost of reinstatement. Do you think the answer is the same as the previous one? The correct answer for this question is that the contractor cannot defend the claim because the man is entitled to recover the cost of reinstatement. Why there is a different outcome as to the remedy? Where the cost of reinstatement is reasonable and proportionate to the loss suffered, the court may award damages on a cost of cure basis, even if it is higher than the difference in market value. In this scenario, the purpose of the garage was specific and essential, and the defect renders the garage entirely unusable for that purpose. This makes reinstatement a reasonable and appropriate measure of damages. Courts have recognized this in cases such as Burst Construction v. Eastern Telegraph, where cost of cure was awarded due to functional failure, in contrast with Ruxley, where the garage in that case was still usable despite minor deviations. Here is the third tricky question. Same fact as the second case that the man intended to store his large commercial car, but shortly after completion, the man's commercial vehicle was destroyed in an unrelated accident. He is now considering purchasing a similar replacement vehicle in the near future, for which he will again require a garage of the originally agreed dimensions. The man has issued a claim for £50,000, including the cost of demolishing and rebuilding the garage, and temporary storage fees for the period in which he had the original vehicle. The contractor seeks advice on how to defend the quantum of the claim. Which of the following best describes the contractor's most likely defense? A. The contractor is not liable, as the vehicle was destroyed by a supervening event. B. The man is only entitled to nominal damages, as there is no current use for the garage. C. The contractor can argue that reinstatement is not currently justified, and damages should reflect temporary loss and any future use. D. The contractor must pay full reinstatement costs, as the man intends to buy a replacement vehicle. E. The man is only entitled to restitution of any benefit conferred on the contractor. The best answer is C. The contractor can argue that reinstatement is not currently justified, and damages should reflect temporary loss and any future use. Where reinstatement costs are claimed, courts assess whether the expenditure is reasonable and proportionate in light of the claimant's actual and future needs. Although the man currently has no vehicle requiring the specified garage size, he intends to purchase a similar one. The court may defer or limit damages to reflect the fact that reinstatement may become reasonable later, or not at all, depending on whether the car is actually replaced. The correct measure may be temporary loss plus a contingent sum, not immediate full reinstatement. Legal principles we went through today. Case 1, minor defect, garage still usable. Reinstatement damages are not automatic. They must be reasonable and proportionate to the benefit they confer. Case 2, total loss of functionality. Courts will prioritize expectation loss when loss of function is clear and significant. Case 3, intended future use, new car planned. Damages may be awarded conditionally or in part, based on how the claimant's situation evolves. Have you noticed how a slight change in facts can lead to a completely different legal outcome? That's exactly the skill the SQE tests, and mastering it is key to exam success. I published books filled with MCQs, each built with 3 variations of a legal scenario to sharpen your analysis and deepen your understanding. It is a must-read to pass SQE 1. It's not just practice. It's a smart strategy for passing the SQE with confidence. Turn your ambition into qualification. Begin your SQE journey to become an English solicitor.